Hello, I'm Howard Bentham and welcome to this special virtual event from OxLEP Business in partnership with Newable and the Department for International Trade. Our focus for the next 90 minutes or so, with the input from some senior figures directly involved in managing the UK's transition, is to keep your business moving and really find out what Oxfordshire's SMEs need to know about the EU exit. Before I introduce our guest speakers, please allow me to deal with some parish notices which should help the event run smoothly for everyone. Firstly, if you're watching this as a live event, we need to make sure you can all see and hear my screen. Can I just ask you all to type the word yes into the question box on the drop-down menu, and that'll tell us that you're all connected properly. We really do appreciate this. I guess even the school register has moved with the digital times that we're in. So type the word yes. We're going to ask all of you to do that into the question box. If you are having a tech problem, please post a private message into the chat space and someone from the Newable team will get straight back to you and try and help resolve the issue. Today's presentation is being recorded and a copy will be sent to you with the accompanying slides within the next 48 hours. We really want to make today's event as interactive as possible, so please feel free to add your comments and questions into the question panel. We'll try and answer as many of these during the broadcast as possible, and we'll have a dedicated Q&A section at the close of the event. Naturally, there may be some questions that need further research, but rest assured, we'll endeavour to provide an answer for you post-event. And if you're watching this as a recording, there's always help on hand at OxLEP, so please contact the team via the website at oxfordshirelep.com/UK-transition. And finally, if you do not want your comment or question read out, please write private before submitting your point. I'm sure you'll agree that today's guest speakers make for an impressive lineup of experts, each with a very clear area of specialist knowledge to help your business or organisation navigate these unique circumstances we now find ourselves in. Towards the end of the event, we will look closely at how the law is impacted by the UK's exit from the EU. We'll hear from Claus Andersen, partner in corporate and commercial and life sciences at Royds, Withy in Oxford, on intellectual property, EU data and trade. His colleague at Royds, Withy Adrian Henderson, who's a solicitor in employment and HR, will concentrate upon employment law and travel. David Taylor, who's an international trade advisor at Newable, will give us an overview of the services offered by the Department for International Trade. Plus, we'll hear an overview from Gill Carr, who's an EU transition advisor at Newable. Today's event, alongside the raft of support being made available, is the latest initiative to be launched by OxLEP, recognising our commitment to supporting the Oxfordshire business community at this critical time. OxLEP is determined to play a key role in ensuring that the county's businesses are able to run as efficiently as possible and remain productive both during the pandemic and in a post-EU economy. Our first guest speaker will endorse that commitment. He has over 35 years of experience in economic development, business management, strategy and policy development. He's run his own businesses, worked in the public and voluntary sectors and advised businesses along with local and national government. He's a co-founder of Smart Oxford and part of the Smart Oxford Partnership Board. His current role at OxLEP, Head of Innovation and Inward Investment, involves leading the team and working alongside government and local partners to develop an international strategy and delivery plan for Oxfordshire, promoting the world-class innovation, assets and skills available in the county. With an overview on OxLEP services, here's Sebastian Johnson.
Thanks, Howard. Very nice introduction. So as Howard said, I'm Sebastian Johnson and I lead on innovation and our international work, which includes the work to drive international investment into Oxfordshire and to support businesses to trade internationally, working closely with the government's Department for International Trade. And I wanted to give you all a brief introduction to the work we do here at OxLEP, at the Oxfordshire Local Enterprise Partnership, before we hear from the experts. And we're a government-funded agency responsible for the economic development and growth of Oxfordshire, and since our inception we've seen some significant success with securing over £660 million worth of investment into Oxfordshire, spent on infrastructure such as transport improvements, employment sites and innovation centres, and this investment that we've secured from government has drawn down a significant amount of private sector investment alongside it. We've created, or we've seen the creation of nearly 50,000 new private sector jobs in recent years, and we're one of the fastest growing economies, one that's grown on average 3.7% each year over the last 5 or 6 years. And we're one of only, interestingly, 3 counties in England that's a net contributor to the Treasury. So more money goes into government than comes out of government for Oxfordshire. So an incredibly, as Howard said, an incredibly important area, an incredibly strong area, but with some significant challenges linked to COVID-19 and EU transition as well. Where overall responsibility lies in areas of strategy, business support, skills development, and we work in partnership with businesses, with business groups, universities, colleges, local authorities, and a range of partners across all sectors, nationally and locally. And we promote Oxfordshire, as I mentioned, to international investors as well, and that's where my work lies, promoting the investment opportunities, the talent, and the great place Oxfordshire is to live and work, and the trading and collaboration opportunities as well. If I could have the next slide, please. I mentioned business support services, and we have a range of business support services, from mentoring, peer support, expert advice, access to use of facilities, and grants programs, and I'll just pick out a couple of those for your information. The Innovation Support for Business program provides one-to-one support for businesses who are thinking about introducing innovation into their businesses, and grants of up to £50,000, which do need to be matched, for businesses who want to develop new and innovative ways of running their business, introducing new procedures, new digital practices to run your business more efficiently, or developing new products and services. The Escalate program offers scale-up support for businesses who want to grow and want to grow quickly, again offering grant funding to support those businesses from £1,000 to £25,000, and also supporting businesses with a positive social and environmental impact as well. We've got the Skills for Business program, which helps support businesses develop a skills needs assessment. What are the skills needs in your business, and helping to support businesses to take on apprentices, particularly those businesses who have never taken on apprentices before. And just a quick word on a new project, a new fund that's going to be available next month, part of the government's Getting Building Fund, is applications will be open to bid for up to £100,000 worth of funding for capital equipment to help businesses to pivot into new products and markets, and support developing a more robust and secure and resilient supply chain, something that we've seen hit by COVID-19. That service, as I mentioned, will be launched. That project will be launched next month, so keep an eye on our website for that. If I could have the next slide, please. Well, we all recognise, as Howard mentioned, the impact of COVID-19 that's had on the country, on businesses, on all of us as individuals. So in partnership with our local authorities and the universities, business representative organisations, businesses and others, we're developing an economic recovery programme that gets us and gives us the strongest chance to have a fast and successful bounce back from the economic hits of COVID-19. And we recognise that alongside the challenges of COVID-19, there have been some challenges with the end of the transition period from with the EU that's thrown significant challenges to businesses around importing and exporting, regulations and standards, workforce and people, IP, legal requirements. Many of the things we'll cover today. And with the support from government's Business, Energy and Industrial Strategy Department, we've set up this EU Transition Business Readiness Support Programme that can help businesses get quick answers to the questions and the challenges that they face. And this is where I have to confess that I'm the fraud on this webinar in some respects. I'm not an expert in this area, and why I'll shut up very, very soon and pass over to the fantastic experts that have given their time to us today to provide information and answer your questions. I hope you're going to find this webinar helpful and informative, whether listening live or listening to the recorded version that we'll have available on our website shortly. If you've got a question or need help, then visit the OxLEP website, or you'll get details of how to contact our partners Newable, who are running the support programme for us directly, and they will get back to you. We'll support you in any ways we can. I'll stop there. Thanks for listening, and I'll pass back to Howard so that we can hear from the real experts. Thank you.
Many thanks, Sebastian Johnson from OxLEP. Remember, if you do want to ask a question or make a specific point, then please use the question panel in the control area of this platform. We'll endeavour to answer as many of them in the Q&A section at the end of the broadcast. OxLEP, as we've just been hearing, is very much on hand to help. Today's broadcast is a collaboration between OxLEP, the Department for International Trade, and Newable, who proudly state on their website that their values help foster a culture that generates business confidence. Unlike most things in life, as in business, confidence is absolutely key. Our next contributor works as an EU transition advisor in the Newable team, supporting and assisting businesses with their EU transition, providing advice, guidance, all based on the very latest government details and guidelines. She has extensive knowledge of all aspects of trading in Europe, in Latin America, and in Russia. She has an international sales and marketing background, having spent 30 years working in a range of consumer goods companies, including Boots, Wedgwood, Tata Group, and Walt Disney. Most recently, she spent 6 years working as an international trade advisor for the Department for International Trade, supporting a broad range of SMEs in the southeast region of the UK, having previously lived and worked in the USA, Peru, Panama, Mexico, Spain, and Sweden. For an overview on the services offered by the EU transition advisors at Newable, here's Gill Carr.
Thank you very much, Howard, for that introduction. I was going to say all of that myself, but you said it for me now. So if I could have the first slide, please, so I can explain what we've been tasked to do to help you guys navigate this new world we find ourselves in. So as Howard has said, I have a broad range of export experience working with a lot of blue chip UK companies, but I also spent 6 years as an international trade advisor working for the Department for International Trade, advising a broad range of companies across multiple sectors and all the countries around the world. So hopefully I bring that experience to bear and can help you navigate some of the issues you're currently finding yourselves facing. We do, as advisors, we have access to all of the latest government details and guidelines. We get daily updates, but it can be a little bit difficult for companies to navigate the .gov.uk site, for example. It's a huge source of useful information, but it can be a little bit challenging to navigate, and we probably have more experience than most of you in doing so and can perhaps pinpoint some of the areas that you will need to access to answer some of your questions. We do have other sources of information as well that you might not be so familiar with. So there are a lot of EU websites that have great information on things like rules of origin, HS codes, what tariffs are applicable, what tariffs are not applicable. We work with multiple specialists, such as the UK Trade Policy team, for example, who again have quite specific information that can be helpful. We work with multiple associations, and we have good access to a sort of a brokerage list of companies that can help you with logistics or tax issues or legal issues. So in summary, we probably just have a better idea of where to look for the answers to some of your questions. As an EU transition advisor, I'm also well networked in with the international trade advisors across the whole country, really. But I was a trade advisor in the Southeast for 6 years, so I have excellent connections with them. And they have a wealth of knowledge. So if I don't know the answer to a question, I can guarantee that one of them will, and I can access that, obviously. We do also have access to people like the Institute of Export, the Food and Drink Federation, HMRC, VAT specialists, compliance specialists, e-commerce specialists, to name but a few. So I think what our role is really to pull in some of these specialists so we can get better answers to the questions you pose. What we're finding is companies are asking us questions, but they're also perhaps missing, that they're not realizing that actually there are some other issues that might affect them. So again, we're signposting them to some of the .gov.uk support. There is something called the Brexit checker, for example, that will just help you go through all of the basics of how is this new agreement going to affect you. And it might perhaps highlight some other areas that you haven't already thought of. So in summary, again, our role is really to ensure that you have all of the information and support that you need to resolve the issues and help you move forward successfully. And then finally, you know, it's not all about the EU. I realise that's what we're all focusing on at the moment, but there are other opportunities with some of the new trade deals that the government are looking at and signing. And so we can help you perhaps access some of those opportunities. And if we can't, then we can refer you on to the international trade advisors who will certainly help you and give you some ongoing support. So if I could have the next slide, please. So we will be answering some of your questions at the end of this session. If any of your questions have not been answered, we will get in touch with you and offer some support. And if you would like to get in touch with us, if you haven't posed a question or if you have another question, then please obviously do email us on these details. And if you could just give us a little bit of background as to who you are, where you are, and the basics of your query, then that would be really helpful. So I look forward to working with you. I hope we can support you as we move forward. Thank you very much. Back to Howard.
Many thanks to Gill Carr from Newable. And thank you for watching this special virtual event from OxLEP Business, Newable, and the Department for International Trade on what Oxfordshire's SMEs need to know about the EU exit. Still to come, we'll look in depth with our two expert speakers from Royds, Withy, King in Oxford, how legal matters surrounding IT, data and international travel, amongst others, are all affected by the UK's exit from the EU. But next, let's concentrate on international trade. So many questions, right from the first mutterings of the referendum, centre on how trade would look in our brave new world outside the EU. Many of the Brexit and Remain arguments of the time were matters of the heart as much of the bottom line. But what is the new landscape for international trade, coupled with the effect, of course, of the global pandemic? That's a very difficult question to answer. Our next contributor to our virtual event has more than 25 years of experience working in international business with specialist skills in composites, marine, automotive and the plastics industries. He's helped set up and run a composites manufacturing company in France and has worked extensively across Europe, setting up and running distributor networks. He's worked in the US, both through a joint venture and wholly owned subsidiary, and has experience with technology management and licensing. He sold product into China, working with a main distributor out of Hong Kong and regional sales network in mainland China itself. For an overview of the services offered by the Department for International Trade to help UK SMEs export and be successful, here's International Trade Advisor David Taylor.
Good morning all, and Howard, thank you very much for that very kind introduction. Could we have the first slide, please? I'm going to take just a few minutes, literally 5 minutes, to explain a little bit about DIT, the Department for International Trade, and what we do. I want to explain who DIT are, for those that don't know, what we do, and how we can help. Next slide, please. So, who are DIT? Well, the Department for International Trade is that department of government that's responsible for promoting British trade across the world, for helping UK companies to take advantage of the opportunities offered by international trade in Europe, but also worldwide. We can help companies to understand how to do business in overseas markets, gain insights into global markets, opportunities, open doors, raise profile, and many other things. But how do we do that? What does the network look like? Next slide, please. Well, DIT has some 1,300 staff spread over more than 100 markets worldwide, staff that are there to help UK companies to understand and to cope with the various challenges offered in entering international markets. Here in the UK, we have more than 400 staff, 200 of which are international trade advisors like myself. I've worked for DIT for almost 7 years now, but as Howard said, most of my career has been spent in private industry, as has that of most of my fellow international trade advisors. We've actually been at the practical end of trying to build and create new businesses in international markets, and therefore we do have some understanding of all the practical realities that that involves. Next slide, please. So what do we do? Well, of those 200 international trade advisors, here in the London and the South East, there are some 65 plus, and that obviously covers the Oxfordshire area, where in fact I do quite a lot of work with individual companies. We work with individual companies. We bring that advice close to where you're actually at. So I have probably some 100 to 150 companies that I actually deal directly with that essentially come to me to have advice on all sorts of different issues, to help them develop their export thinking, to bounce ideas as to whether their product or their service would be appropriate in a particular market. We can help them with information and market research. We can set up meetings for them in international markets. Generally help them in terms of looking at their international planning and what they need to put into place in order to be successful in international markets. We can offer all sorts of different types and pieces of advice. I think as Howard said, my particular expertise is in composites and advanced engineering primarily, but I have advisors. In fact, Gill, she was a colleague of mine in the Southeast, and she, as was explained, has a lot of experience in retail. But we have advisors that have experience in energy, in medical devices, in technology, in virtually every sector that you're likely to think about. My particular expertise, as was explained, is in Europe, the US, and over into the Far East. But we have a lot of advisors that have experience in other parts of the world, Africa in particular, and also into South America. So wherever you are thinking that there might be opportunities for your business, international trade advisors can help with practical, realistic advice. Next slide, please. We have a portfolio of services that we offer. I've already spoken about the one-to-one advice, but DIT can also help with things like trade shows. Not many of those happening at the moment, unfortunately, given the situation with COVID, but as they return, then the DIT can help with support for those trade shows. We also have international opportunities published through our websites, and you can have contact into those opportunities through the global network that we discussed a little earlier. We organise events, mostly virtual, of course, at the moment, where you can meet buyers in international markets, workshops, masterclasses, look at how to win business in overseas markets, and perhaps how to modify your promotional materials to make sure that they have the best impact on your target markets. Next slide, please. One area that's really grown in terms of promoting companies internationally over recent years is selling online. And we have a dedicated specialist service for those companies that are selling online internationally, where you can get advice from specialist advisors and actually get connected into some of those international marketplaces. Amazon seems all dominant, but in truth, there are many, many other marketplaces around the world which for certain companies will prove even more effective than using Amazon itself. Next slide, please. As well as advising on online, there's also a whole series of useful tools that are published, which do cover some of the practical aspects of exporting. And as I think Gill referred to earlier, given the current situation in terms of the end of the transition period, I think most international trade advisors like myself have had an awful lot more questions related to those practical aspects, be that from HS codes to tariffs, to rules and regulations, phytosanitary certificates and CE marking, to anything really that companies need to know in order to help them with their international trade. We're there to help, and we will try and answer whatever questions come our direction. As you can appreciate, we're not able to answer absolutely every question, which is why we network in with the likes of Gill and various other professionals that have expertise in areas that perhaps we're not experts ourselves in. Next slide, please. There is much help online for the end of the transition period, but as Gill said, it can be a little bit difficult to interpret. So we're there to help you to actually find the right information that will help you to understand what is happening. The Trade and Cooperation Agreement that was agreed just before Christmas contains an awful lot of detail, more than 1,000 pages worth. I haven't trawled through all of those pages, although many of my colleagues have and will have that information to hand in order to try to answer your questions. So whatever that question might be, whether you come directly to an international trade advisor like myself or to Gill or through OxLEP to their various support mechanisms, then we will try and answer as clearly and as practically as we can those particular questions. Next slide, please. There's a question and answer session at the end of this particular presentation, but also there you have contact details for myself and for the other trade advisors that can help you answer any questions that you might have. And at that point, perhaps I can hand Howard back to yourself.
Many thanks, International Trade Advisor David Taylor. I'm sure you'd agree that we've already covered a lot of ground with our first three speakers. We've heard about the help that OxLEP Business can offer SMEs in the county, the wide-ranging support from Newable, plus the government's intentions to help realise the new possibilities for business that are now achievable under the stewardship of the Department for International Trade. If you do want to ask a question or make a specific point, then please use the question panel in the control area of this platform. Our Q&A section, as Dave mentioned, will be at the end of this broadcast. In the next section of this virtual event, we're going to focus on the legal implications of the UK's exit from the EU. As I'm sure you'll appreciate, this is a wide-ranging and complex area. With the help of our next two experts, we'll hopefully shine some light on how things will look now in a legal context going forward. One of the big questions business people have been asking is, how will the UK's exit affect travel for work and employment in Europe? There are so many aspects to this. Will I need a working visa or a permit? How long can I stay? What about freelance workers? How does it affect workers' rights? The list goes on. Our next speaker is a partner in Royds Withy King's corporate and commercial team. He deals with all aspects of corporates and commercial work for corporate clients, limited companies, businesses, private individuals and trade organisations. A dual qualified lawyer in England and Wales as well as in Denmark. He currently heads up the firm's Brexit task force. With an overview on the rules surrounding employment and travel, here's Claus Andersen.
Thank you very much, Howard. Thank you for that introduction. My name is Claus Andersen. I'm partner in Royds Withy King in the corporate commercial department. And I was just... Can you see my presentation?
Just to confirm, we can see your presentation.
All right. So I am speaking about trading with the EU. That will be intellectual property, personal data, and the general trading rules. Now, these rules are in all of them very, very huge rules, and one could spend a whole day on these sections. I've got around 20 to 30 minutes, so this will be a brief overview. As was mentioned, the Trade and Cooperation Agreement is more than 1,000 pages long, so it will obviously it can only be an overview. You will see the subjects I'll speak about. I'll speak first about the effect of Brexit, the new trading relationship with the EU and UK, import and export, bit about intellectual property and personal data. So the next slide about the effect of Brexit. In one thing that I think is often forgotten in the advice and in the discussion about Brexit and the new trading rules is what the effect of Brexit actually is. So if one looks at, you know, what was the main features of the EU membership for businesses, it was basically the free movement of goods, services, capital, and labor. It was also membership of the customs union, which supported the free movement further. So until January 1st this year, businesses did not worry too much about goods moving from, let's say, the UK to Germany. By exiting the EU, this free movement has disappeared and is basically being replaced by the EU-UK Trade and Cooperation Agreement. And what that means is that the smooth trading free movement is disappearing, and therefore it is important for each business to consider first, what does that mean for them? How did the businesses rely on the free movement, and what does it actually mean that it now disappears? I think it's important to say that each business will be affected in different ways. So what may be good for one business may not necessarily be good for other businesses. As it was mentioned, if we sort of rewind a bit, obviously since 2016, there's been a process starting with the referendum, whereby the United Kingdom gradually negotiated its way out of EU. We saw in the beginning of 2020 the withdrawal agreement, which deals with the exit from the EU, and now just before Christmas last year, the trade agreement between the EU and UK was entered into, and I will speak a bit about that agreement. The fundamental feature of this free trade agreement is that it secures tariff-free and quota-free trade in goods. It is therefore an agreement that predominantly deals with the trade of goods. There are some statements, some sections about services. There are also some other sections about IP and data protection, which I'll come back to. But in essence, it is an agreement that deals with the trade in goods. And what it means that it's tariff-free and quota-free means that as a starting point, UK products will not be tariffed when they travel from the UK to the EU. There may be other levies, but there will not be a tariff, and there will also be quota-free, so there's no restriction. Furthermore, there is an obligation in the agreement that to not carry out any discrimination against imported goods. To qualify for this preferential treatment, the products need to come from either the EU or UK. What that means is that that they are set out rules of origin, which broadly speaking means that products from produced in the EU can tariff-free exit UK, and products produced in the UK can tariff-free access the EU. I should mention that there are some quite detailed and complicated rules about how those rules actually work, and therefore what I would suggest is that if companies proposing to export to the EU, insofar as there are other products incorporated in their goods, i.e. products from outside the UK, that one studies the rules of origin. HMRC has got a very good guide on that specific topic. What the trade agreement also sets out are framework rules for sanitary and sanitary examinations. Those are the health checks those are the checks on the goods when they cross into EU or into the UK. It's important to note that there is no decision on mutual recognition of standards. However, there are set out a framework of provisions which should secure that trade is not unduly prevented between the UK and EU because of discriminatory rules. The same applies to technical barriers to trade. The trade agreement does not do away with such barriers, but it does provide a framework within which those can function. And it should also be mentioned that there are also extensive provisions about customs cooperation. So that is the free trade agreement in brief. There are obviously many facets to it, but that's the basic mechanism. What EU's, and I'm now going to speak about import and export, what the exit from EU also meant was that the tariff system, which the United Kingdom used to be part of, because of the membership of the EU's common external tariff, has been replaced by the UK's new global tariff system. So these are tariffs that apply when goods are coming from coming to the UK. They do not apply to goods coming from EU because the Trade and Cooperation Act applies, but they apply to goods coming from countries like the USA, India, Brazil, China, and Australia. The main purpose of the new global tariff system was to simplify and in many cases reduce the tariff that had been put on a number of goods. Also to in some cases to quite simply do away with some of the tariffs. So in all, that is the tariff system that importers should look at when you are importing products from countries which are not subject to a free trade agreement, such as the Trade and Cooperation Agreement. That leads me up to the second point, because or the second type of trade agreement, because in addition to the negotiations with the EU, the UK government has been involved in a number of negotiations with other countries, primarily with countries which have a free trade agreement with the EU. And the purpose of the trade negotiations was to replace those trade agreements with new trade agreements that would apply between the UK and those countries which have free trade agreements with the EU. So in the course of 2 years, the government has agreed around 62, 63 trade agreements, and in that, some of those agreements are, for instance, agreements with Switzerland, Norway, and also in the autumn a quite significant agreement with Japan. So these agreements would set out what, if any, tariff is applicable for goods coming into the UK from those countries, but also specific rules of origin, which also must be put in place, or which also must be sorted out in that regard. One of the features of the UK's exit from the EU is that when exporters are considering putting a product on the market of, let's say, an EU country, exporters will now need to consider whether they have got the correct license and whether the destination country's standards have been complied with. So I think it's fairly important to keep that in mind. Obviously, because the UK has just left the EU, the standards will more or less be the same, but over time they will no doubt develop in different directions. Another aspect of the preparation for export is that companies need to have a URI number in order to export goods, and will also need to get used to fill in export and customs declarations. And all in all, I think it's fair to say that it will become more important now to plan any import and export very carefully, not just logistically, but also to look at some of the contracts that businesses are entering into with their business partners. I think it will be prudent to have a look to see if they are still fit for the new trading regime. Now I will speak a bit about intellectual property and personal data. Intellectual property, again, if we go back and look at intellectual property, there were significant provisions in the withdrawal agreement about the status of the intellectual property at the time of exit, i.e. to which extent trademark, etc., already registered trademarks could be enforced in respective countries. There is a section on intellectual property in the trademark, in the trade and cooperation agreement, and broadly speaking, this section provides a framework within which there are minimum standards which the UK and the EU have to comply with. There are EU and now the UK are obviously member of a number or signatory to a number of international agreements on intellectual property, and there is a commitment in the trade agreement that such membership, partnership in those agreements shall continue. Also, there's quite significant that nationals from each countries or from each trading bloc should not receive a less favorable treatment than nationals from home countries. That basically means that UK nationals should be able to enforce trademark violations in France as so far as it's possible under that trademark system. There should also in both trading blocks be measures and procedures to enforce intellectual property, and both the UK and the EU commits themselves to continue working together about these commitments in the trade and cooperation agreement. Finally, one thing that is of huge importance for many businesses which are relying on personal data. The issue, as many of you no doubt knows, is that obviously we had GDPR coming into force in 2018. It's based on a European regulation. In the UK, that's been implemented by the Data Protection Act 2018. One of the aspects of the GDPR is that there are restrictions as to which EU businesses can transmit personal data to third countries. And this was my point in the beginning about looking at what actually happens with Brexit. Now the UK is a third country. It's no longer a member of the EU. Therefore, a transfer to the UK could potentially be problematic, and that is obviously an issue for many businesses which rely on the transfer of personal data. That can be cured if the European Commission issues an adequate decision, which basically sets out that, all right, even though the UK is a third country, a transfer of personal data to the UK is okay under the GDPR. We have not yet seen such adequate decision. Some people say that it should not necessarily be an issue for the United Kingdom to receive that, but it is not a given that the EU Commission will provide such adequate decision. There are some concerns in EU about the surveillance in the UK, the membership of Five Eyes, but also that the government has previously set out that it potentially could change the Data Protection Act 2018. Therefore, in order to avoid a cliff or a certain stop for transfer of personal data from the EU to the UK, the Trade and Cooperation Agreement has provided an interim situation, a bridging period whereby people and businesses in the UK can transfer personal data to the UK for 4 months from the date of the agreement. That can potentially be extended with 2 months, or if there is an adequate decision before that issued by the European Commission. But as we do not know for sure, whether such adequate decision will be given, I think it will be prudent for businesses in the UK relying on data from the EU to plan for the situation where they may not necessarily, or the UK may not necessarily be given that adequate decision. That can be cured by using some standard clauses in the contracts, and it's also something that companies should consider. A final point should be that the United Kingdom has provided an adequate decision in relation to data from that's being transferred to the EU. And that concludes my presentation, so I will hand it back to you, Howard.
Many thanks, Royds, Withy, Kings, Claus, Andersen. Safeguarding intellectual property has always been an imperative for all businesses. Has the EU transition prompted a change in this area? Our final contributor is a colleague of Claus's at Royds, Withy in Oxford. He's an experienced employment lawyer, advises on contract and policy drafting, negotiating settlement agreements on behalf of employers and employees, disciplinary and grievance procedures, and tribunal claims. As part of the firm's business immigration team, he advises large companies, SMEs, partnerships, high net worth individuals, entrepreneurs, and highly skilled workers on the UK's fast-changing immigration laws and processes. For an overview on the rules surrounding intellectual property and trade, here's Adrian Henderson.
Thank you very much, Howard. That's much appreciated. I have been handed the controls here in terms of screen sharing, and like most, like many lawyers, I get quite nervous when I'm handed the technical controls of pretty much anything. In common with Claus, I'm going to ask if I'm just going to try and do this now, make sure that I can share the screen. Possibly it's been paused for some reason, so do bear with me for a second.
Thanks, Adrian. We could just see the Word documents. We just need you to select the PowerPoint presentation. So if you click into the sharing tab. Sorry about this, guys. The joys of an online live event.
Yes. Okay. So my screen sharing is now paused. Okay. Right. Do bear with me a sec.
Do you want me to share your slides for you?
If you could, that'd be great. I think that's probably going to be the easiest way of doing it.
That's all right. Bear with us a second, we will be back in just a second.
Okay. Great. Okay then. Okay. So can I now check that the presentation slides can now be seen?
Yep, everybody can see them.
Excellent. Well done. Well, sorry about that, everybody. As Howard mentioned, I am an employment lawyer based at Royds, Withy. The focus of today is of what I'm going to be talking about over the next 15 minutes or so is employment and travel, specifically in relation to business immigration. As is probably quite unsurprising to everybody here, one of the most hotly debated areas of the post-Brexit settlement has been immigration and the ending of free movement of labour that was promised as part of the 2016 referendum. And with the end of the transition period at the end of last year, freedom of movement for both EEA nationals coming to the UK and UK nationals wanting to live and work in the EEA is no more. Now, a couple of things that I'm just going to mention now. The focus, just to differ slightly from what Howard mentioned, I'm going to be talking about immigration and partly on travel. I'm not going to touch on intellectual property within this discussion. And just something about some of the technical terms I'm going to be using. I'm talking about EEA immigration. That is effectively the EU plus Norway, Liechtenstein, Iceland, and for the purpose of what we're talking about here, Switzerland as well, even though Switzerland is not technically in the EEA. I'm going to be talking as well about the situation in regards to EEA nationals already living and working here, and the systems in place for those individuals and how these differ from EEA nationals who will be wanting to move to the UK for work purposes after the 1st of January, i.e. after the end of the current transition, as the previous transition period had come to an end. Now, the thing to bear in mind here is that effectively the previous two-tier system of EEA migration and non-EEA immigration is coming to an end. So prior to the current system being in place, there were effectively two different systems, one for European nationals and one for non-European nationals. That two-tier system has now effectively been abolished, and there is one immigration system applicable to all migrant workers. Now, the one exception to that is in the case of Irish nationals, and Irish nationals will be retaining their freedom of movement going forward, and that freedom of movement happens in both directions across the Irish Sea. Now, the impact on travel has probably been slightly less, has had slightly less of an intense focus, I think, it's fair to say, than the general immigration system. We just had huge numbers of questions over the last few years, and many of them have only been answered in recent times, and many HR professionals, businesses, and indeed lawyers have been imparted with the knowledge of that fairly recently. So there are still some questions to be answered on that, and I'm going to come to those in due course over the next 15 minutes or so. The rules on travel will have an effect particularly on business travel and particularly on visa-free travel. So what will be permitted in terms of EEA nationals travelling to the UK, and activities that are permitted outside of the visa scheme, and to an extent what will be happening the other way. So UK professionals visiting the EEA for business purposes. Now, unfortunately, and I think that it is unfortunate. I think a lot of HR professionals and immigration lawyers were a bit disappointed on the fact that these arrangements were not incorporated into the recent agreement that was verified at the end of last year. Now, what that means in essence is that the rules on travel and really on immigration more broadly are effectively down to the individual member state and is not effectively a union issue. What that means is that much of the rules on individual questions that businesses may have on their specific representatives and employees travelling to the UK for work purposes will actually need to be referred to with reference to the individual member states and their specific rules that are in place there. So again, I'm going to be getting onto that towards the end of the discussion here. So the first thing to mention here is one of the loudest questions that we're being asked, and is continuing to be asked, is what happens now to EEA nationals who have already been living here now that free movement of labour has come to an end? Do these people now all have to acquire separate visas, or be sponsored by their employers, or maybe quickly get married, or have to claim ancestry or asylum or anything else under the usual immigration rules? Well, the quick answer to that is no, they don't. The EU settlement scheme was set up in 2019 for the purpose of providing a facilitation for EU workers who've been living and working in the UK under their freedom of movement rights, to be able to allow them to acquire living and working rights independent of that. The application process for this is open until the 30th of June this year. So there is a 6-month grace period following the end of the transition period to allow people to take advantage of that if they qualify. And effectively they qualify if they have been living in the UK from 11 p.m. on the 31st of December 2020. They can therefore apply for that status. If the rules are that if they have been living in the UK for 5 years, up to the point of their application, then they will be applicable for settled status, which is effectively akin to indefinite leave to remain. Those who have been in the UK for less than 5 years at the point that they apply will be awarded what's known as pre-settled status. This is akin to limited leave to remain, which will last for up to 5 years, after which point they will then have the opportunity to apply for settled status and effectively gain their right to full settled status and what is effectively indefinite leave to remain. What will happen then is that they will then, following that, be able to apply for ongoing status enhancing programs like the citizenship scheme, for example, the details of which I'm not going to go into for the purpose of this, but suffice to say that effectively is a pathway then to citizenship if indeed the individuals wish to apply for that. Now, what that means effectively is that the rights of EEA nationals will remain effectively the same as they were under their rights to under their freedom of labour rights. So employers will not be rescinding on their obligations regarding right to work checks or preventing illegal working by employing EEA nationals from the 1st of January. That is the thing to bear in mind. We're going to be talking a little bit now about right to work checks and how this works in practice, because there are some obvious questions that this leads open in regards to this. So the right to work checks, in relation to that, some of the fundamentals of right to work checks, which all employers will be used to, are not changing as a result of the post-Brexit settlement. The ongoing obligation on all employers to prevent illegal working has not changed. Okay, so that is the fundamental thing to keep in mind. So as you all know, the right to work checks for everybody who you employ have to be conducted at the start of employment. And that has been an ongoing obligation for employers since the 1990s. And those checks undertaking on new starters, no matter where they're from, effectively mean that employers will continue to need to check that they have the requisite rights to work in the UK, and that is by checking alongside the prescribed list of accepted documents that is published by the Home Office. Many of you will be fully familiar with this and fully familiar with the 3 lists published by the Home Office, broadly speaking, List A, List B1 and List B2. And these are lists of documents that are acceptable. So if the prospective employee produces a document which is on one of these 3 lists, then that's fine. They have the right to work in the UK, and you have fulfilled your obligations in making those checks. The brief difference between those 3 lists, lists A, that is effectively an absolute right to work in the UK. You do not have to do any follow-up checks, but you must keep a record of that check. List B1 and List B2 have follow-up checks that needs to be taken because they effectively indicate temporary right to work in the UK and need to be followed up after that temporary rights expire. Now, traditionally, the interesting thing here is one of the documents that was on List A as an absolute right has obviously been a valid EEA passport, because up until the 1st of January, that was proof that you had the right to live and work in the UK under your rights to freedom of movement. Now, you would think that now the freedom of movement has ended, an EEA passport will no longer be an acceptable document to prove that you have right to work. Now, interestingly enough, that is not the case. As of the 1st of January, an EEA passport is still acceptable proof to work in the UK, despite the fact that freedom of movement has nominally ended. Now, the reason for this is because the EEA passport holders can still live and work in the UK and be able to apply for the EU settlement scheme up until the 30th of June. So for these first 6 months of 2021, that is still applicable. Now, interestingly enough, and quite strangely enough, there is no obligation to do any follow-up checks after the 30th of June to verify if someone has applied for the settlement scheme. So in theory, an employer could find themselves, as of the 1st of July, employing someone with no right to work in the UK and cannot be penalised for this because they will have done all that is required of them by the Home Office. They've checked the documents are correct, therefore they are they've done everything that is required of them without going against any of the Home Office guidance. So that therefore creates something of a loophole and has led to many clients of ours, for example, questioning this and being somewhat nervous about this. Now, my sort of professional opinion of this is that this probably will change, is that between now and the 30th of June, I suspect, and I must say I suspect because I have no concrete evidence that this will happen, but it would seem strange if it didn't, that will change and there will be fresh obligations introduced for employers to do follow-up checks after the 30th of June for EEA passport holders who previously, if they've come into employment after the 1st of January, have proved their right to work via an EEA passport. I suspect that there will be checks introduced to check that as of the 1st of July, those people do have the right to work in the UK. But at the moment, that has not been introduced. I suspect because the government have probably a fair to-do list to work through at the moment, not least because the COVID situation has had a real effect on the ins and outs of visa application processes and whatnot. However, that is something that I would advise people to look out for, and it is something that we will be advising our clients on in the coming months when those developments come through. If and when, I say it's more likely to say when those developments come through rather than if. So the other thing to mention on this is all of this means that in terms of skilled workers coming to the UK, many employers are now having to consider immigration law for the first time, where previously this has never been a concern for them because they have been able to rely on freedom of movement if they have a workforce which traditionally is made up of large numbers of EEA nationals, and if indeed they're concerned about the possibility of high turnovers of staff within the post-Brexit world, and also the pool of available talent to them in a post-Brexit world, with the inevitable slowdown in EEA immigration that will come into play. Therefore, immigration law in a wider sense becomes much more real for a large number of UK employers. So effectively, the basic rule that people need to bear in mind is that all those wanting to hire migrant workers, wherever they're from, including EEA nationals not eligible for the EU settlement scheme, will need to acquire a skilled worker license from the Home Office. This used to be known as a Tier 2 visa. It's what I refer to as the artist formerly known as Tier 2 immigration system. It's now the skilled worker system under the new system. So what this means is that sponsored workers will need to have a job offer from a licensed employer. So all employers wishing to take advantage of this will need to will need to be to apply for and be granted a license to sponsor migrant workers. With that, that application procedure involves demonstrating with clear evidence that you either have specific role or roles that are eligible to be filled through the migrant sponsor system, or you are in a position where you will need to be hiring for such roles in the near future. Acquiring a license also comes with significant reporting duties to the Home Office to check that you're complying with all conditions, and that all license holders must adhere to these conditions. If they do not, or if they are found to be rescinding on these obligations and these duties, they may find their licenses being revoked, and it is very difficult to acquire a license after that has happened. The employer, on being granted a license, will then be able to assign accompanying certificates of sponsorships to the individual they wish to hire. Those individuals can already be based in the UK on a different visa, or they can be overseas wanting to come over on entry clearance. And this will then allow the candidates themselves to apply for the requisite visa. And for this application to succeed, they will need to score enough points on the new points-based system. You may have heard this being applied to over the years as the Australian-style points-based system. I tend to try and ignore that label because basically I know nothing about the Australian immigration system, so I've got no idea whether that's accurate. But effectively, the migrant worker will need to score 70 points in total, consisting of a relevant job offer, proficient English language ability, requisite qualifications, which is effectively A-level equivalent or above, and the requisite salary. The salary will need to be, generally speaking, at least £25,600. But this particular requirement can be traded for other things, such as a place on the shortage occupation list, which is the list of occupations published by the Home Office with specific need, or sometimes specific higher qualifications, such as a relevant PhD, or being a new entrant in the job market. However, it's worth bearing in mind that the absolute base level of salary, even if a migrant worker is able to trade the salary requirement, needs to be at least £20,480. And the other thing to bear in mind here for those people who have been used to using the old Tier 2 system is that the previous limits in regards to the number of certificates of sponsorship that the government are willing to give out to in any individual year is now being abolished, and therefore the previous resident labour market test, whereby an employer previously had to advertise domestically before being able to hire from overseas, is also being abolished, which is something that I know a number of HR professionals have been quite glad about. So now briefly, the final thing I'm just going to touch upon in the last couple of minutes is the general point on travel. Now, as I mentioned previously, the travel to EEA countries from the UK is one that is devolved to individual countries. It's not a union issue. It is not something that was brought in with the trade agreement. Generally speaking, if you want to visit most EEA countries from the UK, you can do so without a visa for up to 90 days in any 180-day period. There are some exceptions. In the cases of Bulgaria, Croatia, Cyprus and Romania. You will also need at least 6 months remaining on your passport for any visa-free travel. Now, for business reasons, if you are planning on staying longer than 90 days or doing one of the following, you may need a visa. I stress may, because this will vary across the 27 member states of the EU plus the four indeed, including Switzerland, additional members of the EEA. And so if you wish to transfer from the UK branch of a company to a branch in a different country, so an intra-corporate transfer, even for a short period of time, you may need a visa. You also may need a visa carrying out contracts to provide services to a client in another country for which your employer has no presence or your company has no presence, and indeed providing services in another country as a self-employed person. There will also possibly be a need for a visa. Apologies for the caveats on saying possible and maybe and all of these terms, but unfortunately these are unavoidable in this circumstance. Now, in terms of the other way for travel to the UK from the EEA, we can be slightly more certain on that. The standard for visa-free travel is 6 months, and in terms of business activities, there are a number of big business activities which are permissible in this sense. For example, attending meetings, conferences and seminars and interviews is acceptable. Giving one-off or short series of talks and speeches, although let's be honest, these are probably going to be via Zoom and other such platforms. Negotiating and signing deals and contracts is acceptable, as is attending trade fairs for promotional work, and providing that the director is not directly selling, and carrying out site visits and inspections and gathering information for their employment overseas. In terms of employee travelling of an overseas company, they may advise and consult and be involved in troubleshooting, providing training, and the general sharing of skills and knowledge. So that is my time up. I believe I know that this has been a whistle-stop tour for both Claus and myself on matters of post-Brexit legal issues. So our contact details are there, so please do take note of them, and we'll be able to answer some questions now. So I am going to hand this back now to Claus. I do hope that my ability to do this is simpler than my ability to get onto this system. So apologies again for the slight stalling at the start there. So Howard, I'm going to hand back to you now.
Many thanks. That's Royds, Withy, Kings, Adrian, Henderson. In fact, the contribution from all of our guest speakers today has been first class, as I'm sure you would agree. And you've been busy too, posting your questions and comments for our panel to answer. OxLEP's Communications Manager, Rob Panting, has been collating your comments. Rob, fire away with the questions.
Hi there, Howard. Thanks everyone for your input. We'll endeavour to get through as many of those questions as possible. I think, as you mentioned at the outset, Howard, for those that we don't answer during the Q&A session, we'll make sure that we get a response across to you all in due course. I've tried to club as many questions together as possible, so hopefully they fall into sort of brackets of interest to everyone. Firstly, in terms of having a business presence in Europe from the UK, one question that we've received has asked, can a UK resident set up a company in an EU country? And just an extension to that that's just come in too. One of our delegates has said that they've been advised that they're unable to move stock from the UK to Amazon EU warehouses without having fiscal representation in each country. So as a last resort, would setting up an EU-based business be the answer to that? So probably a couple of questions for Claus there.
Yeah, what I would say in general is that setting up in Europe, in any of the countries in Europe, will largely depend on local laws. Also, what I think one should consider in that regard is to which extent you need a permission, a license, a authority from a public authority to actually carry out your business in that country. Like in the UK, there will be activities for which you need to apply for permission, like financial services, provision of medical supply, medicines, etc. So I think that's the first point. Also, there will be, as you touched upon, for a number of situations, there will be requirements that you should register for various tax purposes in local laws, which also ties in with a general advice in a situation like that, where you should always consider the tax implications of your engagement overseas. Additional considerations could be employment, insofar as you hire employees, but it could also be contracts, how you deal from that. But in short, potentially it could, for some, be an option to set up in a European country.
Excellent, thank you, Claus. Moving on to the topic of people and also talent within Europe. I think this is one potentially for Adrian to look into. One of the questions that we've received looks at what is the procedure for having EU students joining a UK-based business, particularly in relation to short-term internships.
Okay, well, there is a separate system sort of outside of the parameters of business immigration for international students, and effectively this is the same system that's existed for a long time. It's known as the Tier 4, well, it used to be known as the Tier 4 immigration system, and it's now just the student immigration system, whereby a higher education institution will sponsor a student to study with them, and there are rules within that that allow students to work up to 20 hours a week during any full-time program of study, and that will include internships. There is also, if the internship is not being paid and it's effectively voluntary, then the rules are relaxed again on that sense. So if it's a case of an employer wanting to bring in an EU or any international student who's already based in the UK at a UK-based university, then that's a fairly straightforward process, because the immigration controls there lie with the higher education institution. If, on the other hand, an employer wants to bring somebody from overseas to work on an internship over here, that will involve having to basically work in partnership with a higher education institution to do that. So in terms of international students already based in the UK, providing that they're here legitimately and they have a legitimate Tier 4 or student visa, then a UK-based employer is perfectly entitled to employ them for up to 20 hours per week, or indeed take them on as an unpaid intern, as long as that is a legitimate voluntary agreement and not simply an employment contract when they're not being paid, obviously.
Absolutely, thank you. We had quite a number of questions with regards to people movement from a business perspective, i.e. going to EU countries as a business and what that involves. I think, to be honest, Adrian, you covered that off quite comprehensively in your last slide.
I mean, I'd love to be more specific about that, to be honest, but it is one of the things that we're having to do is advise people based on individual the individual rules with individual member states. We can do that. I don't have the capacity at the moment to go into all 27 different regimes, but we are able to point to general elements which have been seen to be the case, i.e. the 90-day limit on many countries, and the general permissions which are not too dissimilar to the permissions which we know are eligible for people coming in the other direction.
Excellent, thank you. Moving on to shipping and products, again, quite a few questions with regards to how businesses ship their products to different parts of the globe, to be completely honest. I guess in this instance, one of the questions which I think captures most people's points of view is what are the rules on EU suppliers shipping directly to a non-EU customer on behalf of the UK. Essentially, I think it's those that we currently have a free trade agreement with. Klaus, I'm not sure if you're happy to pick that one up, please.
Yeah, I mean, what I would look at it's one of those questions where, in order to provide, more specific advice, you would need to have a bit more detail. I think sort of starting point, I think it's important to look at what is the contractual arrangement between the UK business and the EU supplier. Then I think it's important to look at what the free trade agreement, for instance, if it's South Korea or Japan, what does that actually say? Are there any specific rules in relation to the origin of the products? There may be different formulas, etc., to fill in the product information. You may need perhaps other documents to support that you will be able to take advantage of a preferential tariff treatment in those agreements. I think those are the aspects I would look at. They sit next to what you would call ordinary shipping rules, which normally apply regardless of whether you ship from any country to another country.
Excellent, thank you. I'm very conscious of time, so I'll throw a couple of quick-fire questions that we've received towards the end of the webinar. One is on trademarking. So for businesses that have a UK recognised trademark, will it continue to be recognised throughout the EU post-Brexit?
If it's a UK registered trademark and not a European trademark, then as a starting point, it will cover the UK. Whether one can look at enforcing some rights in flowing from that trademarking outside, it will depend on the situation. It will depend on the local law. It's also important that you go back and look at, when the trademark was obtained, what the circumstance was, if it's possible, for instance, to make use of some of the provisions in the withdrawal agreement about the coverage of the trademark. But as a starting point, a UK trademark is enforceable in the UK.
Excellent, thank you. And then just one final question specifically around companies exporting into Northern Ireland. So this delegate has asked, do UK companies exporting to a company in Northern Ireland require a new Northern Ireland EORI number?
They will require a EORI number, and I believe that there is guidance on the gov.uk on that specific issue. Yeah.
Fantastic, thank you. Those are all the questions, Howard. As I say, we'll endeavour to ensure that we get back to all delegates answering their specific questions in due course, but just to pass on my thanks to everyone for contributing questions.
Indeed, thanks for all the questions, everybody. They are much appreciated. And as Rob says, if there are any points that need further correspondence, then the team from OxLEP or Newable will be back in touch with you. Thanks to Rob Panting for putting your points to our expert panel. We must all say a huge thank you to our experts, Sebastian Johnson, Head of Innovation and Inward Investment at OxLEP, Gill Carr, EU Transition Advisor at Newable, David Taylor, International Trade Advisor at Newable, Claus Andersen, Partner in Corporate and Commercial and Life Sciences at Royds, Withy in Oxford, and Adrian Henderson, Solicitor in Employment and HR, also at the law firm Royds, Withy. Another date for the diary is Tuesday, 16th of March, when we'll be hosting 2 virtual events. The first, Keeping Your Agricultural Business Moving, what Oxfordshire's SMEs in the sector need to know about the EU exit, runs from 10 AM until 12 noon. That's then followed at 2 o'clock with Keeping Your Supply Chain Moving, what Oxfordshire SMEs in the sector need to know about the EU exit. That event runs until 4 o'clock. All the details on these events are on the OxLEP website. Get on to oxfordshirelep.com OxLEP.com/UK-transition. Over the past 12 months, OxLEP has introduced a number of new and effective programs and funds created to provide critical support. This provision has allowed our business community to become more agile and flexible, whilst also encouraging greater levels of business diversification. OxLEP Business is offering companies in Oxfordshire a tailored support service from experienced business advisors. Within this support is free one-to-one advice, answers to your specific post-EU transition questions, a review on the impact these changes may have on your business, and help to develop an action plan. If you want to book a meeting, then visit oxfordshirelep.com/UK-transition for more details. The UK's exit from the EU is a quantum shift in the business landscape and arguably the biggest one in a generation. It's happening, of course, in the middle of a global pandemic that has simply changed how the world functions on a fundamental level, let alone how it does business. There are lots of questions and uncertainty, but there is help on hand. The Department for International Trade is flying the flag and leading the way for the UK. Newable are a fabulous resource with some industry-leading experts on hand to give you guidance and help your business. And OxLEP have genuine expertise and local knowledge in equal measure. It's a combination that will truly help you navigate the next period in this transition. So thank you once again for being part of this virtual event. We've covered an enormous amount of territory over the last hour and a half or so. Your questions and contributions were much appreciated. We will be in touch shortly with a recording of the event and the accompanying slides. Remember, we'll be back in March with events focused on the agricultural economy and the supply chain. So sign up on the OxLEP website. But for now, from me, Howard Bentham, it's goodbye.